the very fact that it is, the delay,
Lordship.
it would be practically about a year and a half, or more than
almost 2 years.
Almost 2 years. Almost 2 years. Would speak about your intention.
Lordship, I have to bow down to.
But in any case, you have come and appeal against the
award.
The award has not been,
That's one of the grounds we are taking. I mean, that's one aspect of the matter. The claimant has, for the past 2 years, claimant has not come forward to enforce or execute that award.
aware?
I'm certain claimant should be aware.
That would be very.
At least if notice goes from honorable court.
We'll look into it.
In case claimant is not aware.
What do you have? Assam?
Yes, madam. One claimant is from.
See, the owner and
Yes,
driver.
Yes, madam. Claimant is from Garo Hills.
This matter has not proceeded ex parte against them.
It's gone ex parte.
Then why would you make them a party?
By way of abundant caution, my lord. I appreciate that lordship has taken the view that if it's gone ex parte in the lower forum, they need not be made parties. But by way of abundant caution, I've put them there. If lordship orders, we will not issue notice against them. It's not required also.
Since you yourself has
by way of abundant caution, I put them. By way of abundant caution, my lord.
Fine. Heard Mr. S. Jindal, counsel for the petitioner, who has submitted that this is application filed under Section 5 of the Limitation Act. Is for continuation is made with a prayer for continuation of delay of 563 days in preferring the related appeal against the judgment and order, as well as award dated 12/9/2022, passed in MSC number 5 of 2013 by the learned member MECT Tura, who is Garo Hills. However, at this stage, the learned counsel would submit that notice may be allowed to be issued by the opposite parties. Accordingly, let notice be issued upon the said respondents, the same returnable within 2 weeks. Is the matter thereafter.
Daily list, item number 1.
May it please your lordship. Lordship, in this matter, the respondent number 1 and 2 were supposed to file their counter affidavit.
But enough time has been given to this one.
I think the only requirement for the respondent number 1 is to produce the relevant notification, isn't it? Is it notification?
Maybe this is the last chance, I think, your lordship, because
You have filed.
I filed in September, long back. 23 I filed.
Mr. Counsel, appearing for respondent 1 and 2, has submitted that the counter affidavit could not be filed today and has sought for time, some more time for the same to be filed. On premium, it seems allowed. Let the said counter affidavit be filed within the next date fix. This is a matter of 2 weeks. The last time around, you said only the concerned officer.
They just need to sign it.
Just to sign, yes.
But he must have signed by now.
Yes.
Please ensure that it's done. You cannot just keep matter hanging on like this.
Obliged.
I do.
Item number 2. May it please, Your Lordship. Lordship, I humbly pray for Passover, Your Lordship. I humbly pray for Passover, Your Lordship.
End of the boat.
Lordship, Monday, Your Lordship. Monday, Your Lordship.
Passover means end of the boat. 2015 matter, Mr.
Lordship,
How many times would I impress upon the parties that
bow
it
down.
has to be heard? In fact, I think Mr. Chaji was not there the last time around.
No, last time I was there. Last time I was.
What will he, if you see, you also have to consider the matter in its proper perspective. If your presence is not required,
Lordship.
then we should do away with your application, hear the matter on merits, and the outcome would, see, if it may be beneficial to you, it may not, because eventually what happens is the consequence of any order passed by this court. If the matter is remanded, then you get a chance to appear before that forum. Otherwise, coming here would serve no purpose as far as you are concerned.
Lordship, if
Lordship, in this case, the entire thing started with the complaint of the present this complainant, and she is representing the complainant. On the basis of this complaint, cognizance was taken against the registration of a plot of land in the RR colony. So on that, the Deputy Commissioner's office passed an order which was challenged before the Revenue Board. Revenue Board also upheld the order of the Deputy Commissioner. Against that, they have filed this revision. So during the pendency of this case, the complainant happened to expire. That is where she has filed a substitution. I believe this is what I understand.
Lordship.
Because now, see, you understand, what we have to do now. We are going. You see, we are sidetracking the main issue and going to the issue of the bona fide of your presence, either as a substituted party to be pleaded, or as legal heir or legal representative of the deceased respondent. This is complainant or respondent, whatever the case may be. So that has to be decided first.
Lordship.
Then we go again to the main. So that would take some time. So we were, in fact, the parties the last time around we are of the opinion that the issue would be decided on merit, and then we'll see what is the outcome.
Lordship, if since Lordship, when my name was deleted after after the complainant's expiry, when the name was deleted, the petition, the present appellant has not taken any steps towards issuing notice to the legal heirs. So the legal heirs stance was that is what I have praised. Unless and until I am substituted or I am impleaded as a legal heir in this case, my rights would get infringed in the Revenue Board, because my complaint, in basis of my complaint, the Revenue Board case was initiated. Now, if my name is deleted here and I am not impleaded, I am the main party, entire matter arose because of my complaint, and my name is deleted here. So, the legal heir, as a legal heir, I am the sufferer. So, in one date, yes, of course, in one day, the order will reflect that in all other dates I am present, except in one day.
That is okay.
Except in one day. Lordship, actually, it also happens that in Wednesday, I used to be in Nongpo for evidences, Lordship, land acquisition matters. So I got stuck there.
If that is the case, I think that is also the opinion of this court, that we should not delay this. Now, the petitioner has come with this prayer.
My
It should
apology,
not be allowed, in fact.
my apology, Lordship. I tender my sincerest apology, Your Lordship, before this honorable court.
Why would you apologize?
But we were, in fact, this matter has already been heard, as your lordship is aware. The only in terms of your lordship's last order, they were required to file some compilation with regard to what actually they want. Some citations, or some authorities they were required to cite in order to buttress their argument that it's a case of impleadment. Now, otherwise, my lord, your lordship is aware that the impleadment has already been rejected.
No, Lordship, it was not the case. It was on Barden lies on.
And your lordship has already come to a conclusion that their appearance, their participation in the proceeding is no longer required. The legal here is, my lord, here they have filed an impleadment application. Your lordship is aware, and after a substantial delay, now even to overcome that, my lord, they have filed an impleadment. Now your lordship is aware that why impleadment, when impleadment is required, and when is.
See, Mr. Thapa, have you advanced argument in that?
We have done, my lord. In fact, it was not me, Mr. Paul, my lord,
whatever.
had
I mean,
advanced
you
the
means
argument on
the
the
party.
earlier occasion. In fact, both of us were heard. Thereafter, your lordship was pleased to grant the petitioner, who's
Oh, I
for
think
some time.
yeah, for some authorities.
Yes,
to-
yes, yes, yes.
Lordship, the argument was advanced. Authorities on both of us, Lordship. It is not on only on me. I have already placed the authority on that day itself. Lordship, I have pasted some citation on that day itself, Lordship. Now the authority was also on them to place.
Yes, yes, yes.
No.
So it is not only us, Lordship. I have already, when I was advancing my submission, I have already placed some of the authorities during my submission that in writ petition such and such things were allowed. Subsequently, I advanced my.
In fact, your lordship, the query of this honorable court was very specific. Whether she wished to file an impleadment, or it is the striking off or addition of parties. That was something that they were required to clarify. Because your lordship had opined that insofar as impleadment is concerned, it's no case of impleadment. Why? Because, lordship, because she is basically trying to derive the title from the earlier owner. Now, earlier owner, your lordship, has already rejected the application for substitution. So therefore, the impleadment doesn't come. So there, the honorable, this honorable court had made a query as to whether it will be an impleadment or a striking off. And as long as your lordship has already held that their substitution is already rejected. Now the substitution is already rejected; they cannot come from impleadment.
It may be just an observation, though.
Yes, your lordship.
There
Was no direction
is
to
not
that
yet
effect.
final.
Yes,
No,
yes.
You see, the arguments of the party will still have to be weighed.
Lordship.
Correct.
So in that, you see, in that respect, what is required at this point of time is if the parties have said that the matter has been argued.
As it is,
As
your
far
lordship.
as far as this petition is concerned.
Correct.
So, and now we are only at the stage of, whether some authorities are required to be produced for this court or not. So, as far as the petitioner is concerned, or the applicant is concerned,
Yes.
Ms. Varsaji has said that she has filed the relevant authorities.
I am not aware of that, man, because on the
I
last
placed,
occasion, on the
uh,
date when she was supposed to file that, she was absent.
No, have you given them copies?
I have given the citation, Lordship.
Fine, we'll do one thing
Lordship.
to make the matter easier and also for the court to be able to comprehend the issue. You file a brief written argument
Written argument, Lordship.
only on this point with authorities.
Lordship.
Fair
And
enough.
if authorities are to be exchanged, you do that.
Lordship.
As it is, your lordship, we are sealing the order passed by the deputy commissioner. It's the state who has
so
to.
You
We'll do that, your lordship. We'll do that.
raise your points of contention.
Absolutely.
Please do that.
Lordship.
But only
A
1 week.
week's time, my lord, I have no problem.
Lordship.
This will be in the miss case, isn't it?
Lordship.
Learned Mr. S. Thapa, as well as Ms. P. Prasadi, learned counsel for the parties, relevant parties, have submitted that the contention raised in this application has been put forth by the parties in course of hearing of the matter. However, at this juncture, it is prayed that brief written synopsis of the said argument with related authorities may be allowed to be filed. Accordingly, all the parties involved are may file such written argument for consideration. This is matter after 1 week.
Lordship.
So, Mr. Sengupta, if you want to comment any your argument,
obtain its if required.
can you come in case this is matter to 1 week? So 1 week,
Yes, sir.
please. This is a very, very old matter. We should try to dispose of.
Lordship. Obliged.
Item number 4.
Item 4, I'm praying for some time, my lord, due to non-availability of Mr. Paul. This is that matter, my lord, where
You're letting him off the hook. He was,
it's okay, my lord. Sometimes we have to give them some space.
but see again, this is a 2019 matter.
19 matter, my lord. But here we also require certain instructions because, as your lordship is aware, that my lease agreement is thought to be cancelled. Now, apparently there were certain notices issued. Now, my lord, after that, what has happened, we are not in the loop.
Exactly. I think the query of the court, as far as the respondent authorities are concerned,
My lord.
is when the lease has been cancelled or not renewed, matter ends there.
Correct.
What you should have done is, as the petitioner, you should have come before this court against such action of the respondent. But you have not done that.
My lord, we have actually done that. My lord, we have approached this honorable court because they were neither renewing my lease agreement in spite of there been letters to me saying that the matter is under consideration. There was neither any action taken on my representation or for renewal. In fact, there was a notice issued to me to vacate the place. So there was two situations, my lord. One, they say that my application for renewal is under consideration. On the other hand, they issued the notices for eviction. So on that premise, my lord, we had approached this honorable court.
On prayer made by the parties, on joint prayer made by the parties seeking accommodation, matters adjourned. Let's say after 1 week. 1 week?
Let it be after 2 weeks, my lord. I'll take some instructions in the matter. Let it be after 2 weeks, my lord.
2 weeks. That's 4 and 5.
4 and 5, my lord.
Item number 6.
My lord, in this matter, my lord, again, the connected issue is pending before the division bench. We have assailed my lord, the actions of the state respondent, my lord, in amending the Excise Act. Of course, the issue here is different. The amendment is challenged before the division bench, my lord, the virus of that particular amendment. Insofar as this writ petition is concerned, my lord, here we are basically challenging the action of the state respondent in allotting, my lord, a certain private individual with the tender, in spite of that there being a single tender. The Lordship is aware that when it comes to single tender, it has to be retendered. It cannot be allotted to a person by way of a single tender. So this matter is, again, my lord, in that way it is connected. The main matter is before the division bench, my lord, still pending. We can have it after.
No, is it, if it is directly connected?
It is connected, my lord. It will have a bearing on this. The division bench matter will have a bearing on this writ petition as well.
My lord, it is relating to setting up of the central bonded warehouse. And before division bench also.
Yes, I understood.
Yes.
With regard to bonded warehouse.
That is understood. You see, that is understood. The only thing is here you said the tender for setting up of the bonded warehouse.
No, my lord.
Yes.
Yes.
And yes, that is in challenge. And there they have challenged, same party has challenged the policy of the government of Meghalaya
Central bond
regarding
warehouse was created.
of the bonded warehouse. My lord.
Then a counsel for the parties have submitted that the related issue pending for adjudication before the division bench of this court is yet to be disposed, decision of which will have a bearing on the merits of this case. It is therefore prayed that the matter may be adjourned for the time being. On prayer made, matter is adjourned, list the same author.
Lordship, if I may, the division bench matter it will be listed on the 23rd, my lord, of July. So after that, my lord.
3 weeks?
4 weeks, my lord, because
It will be
it
up
will
to
take
4
some-
weeks, my lord, since
4
it's on
weeks.
23rd.
4 weeks then.
Deeply obliged.
All right.